Good afternoon. This is Allison Baker, and I want to welcome you all to Venable's new Paycheck Protection Program Flexibility Act, how it will impact the Paycheck Protection Program. And I have with me today a fantastic group of panelists, starting with my partner, Meredith Boylan, who's a partner in our financial services practice and a very seasoned litigator. My partner, Chuck Morton, who is chair of our corporate practice here at Venable. My partner, Art Cyrilnik, who is a senior corporate partner based in our San Francisco office, and my partner, Chris O'Brien, who is a senior partner in the corporate practice based in our Los Angeles office. And I'm Allison Baker. I'm chair of Venable's financial services practice. And today we're going to be discussing the new Paycheck Protection Program Flexibility Act, how it has changed and amended some of the former PPP rules, as well as recently promulgated interim final rulemaking, which has also changed some of the original rules of the PPP loan program. So we have a nice agenda today, and as usual, we will be taking questions throughout. We'll be trying to incorporate answers to questions throughout, and then at the end, if we have some time, we also will be answering questions. So first of all, as I said, we're going to be discussing the Paycheck Protection Program Flexibility Act. On June 4th, the President signed into law the PPPFA. It was passed by the Senate the day before, on June 3rd, and it was passed by the House a few days earlier. And then subsequently, earlier this week, the SBA posted an interim final rule amending the agency's first interim final rule. So some of these new rules and provisions of the CARES Act, the PPP program, are very critical to how the loan program continues to work, and they alter some of the original terms and conditions as well. And so we want to spend some time today updating the audience on that. First of all, if we can go to the loan maturity provisions. So the Paycheck Protection Flexibility Act amends in some way the loan maturity provisions of the original PPP program. And I want to start at the top. So initially, when the CARES Act was passed, Title I of the CARES Act was passed on March 27th, the law said that the loans that would be offered under this program would not exceed a maturity of 10 years. So in other words, the term for the loan, the PPP loan, as originally contemplated under the CARES Act statute, contemplated at least no more than a 10-year timeline for the loan's term. Now, subsequently, there were rules that were passed, or promulgated, I should say, that provided specifically that the loan maturity date would be only 2 years. So we went from an assumption that it could be 10 years to the rule reality that it was 2 years. And suffice to say, that did cause some concern in quarters where folks were concerned that they may end up having a loan that had to be repaid in a much shorter timeline than they had originally contemplated, assuming that they weren't able to have the entirety of the loan forgiven. So that was something that animated the next step, which was the Paycheck Protection Flexibility Act, which, as we said, came into law last week. And what that does is it says that the minimum term of maturity for a loan is 5 years. But the kicker is that that provision applies only to those loans that are made after the Paycheck Protection Flexibility Act was amended. So if you have one of the loans that was made before June 5th, which is probably the bulk of loans out there, then the term on your promissory note is not necessarily a minimum term of 5 years. Having said that, the interim final rule guidance that came out earlier this week contemplates this exact situation and says, look, the 5-year maturity automatically applies only to loans that were made after June 5th, when the Paycheck Protection Flexibility Act was passed, but it also enables or contemplates at least a scenario where a borrower might negotiate with its lender revised terms and conditions in the promissory note that would extend the maturity of the loan out to 5 years. Now, query as to how functional that is and to how practical that is, but that is what the rule says. So we have an interesting situation where we have differing maturity dates for loans. Obviously, folks who took out their loan a couple months ago at this point, with the assumption that that loan was a 2-year term, only to learn now that people who kind of waited a little longer are getting loans with 5-year terms. And in some way, we suspect that that might be material to some decisions that get made going forward. But we wanted to keep the audience posted as these developments come into light. The next issue that we think is critical here concerning the PPFA goes to deferral and payment provisions. So not only does the PPFA address the change in terms associated with new loans that are made from 2 years to 5 years, it also addresses a few issues around how long lenders can defer payments for. So initially, the CARES Act requires lenders to defer payments, and this includes principal, interest, and any fees associated with the loan for the PPP loan for at least 6 months and up to 1 year. And so functionally, again, it was contemplated that borrowers would seek forgiveness of the loan, and given they would do so during the 6-month deferral period, functionally converting all components of the loan into a grant or nearly a grant. Then the interim final rule said it's not up to 1 year, it is only for 6 months, the deferral period. So again, it was still contemplated that the forgiveness period would happen within that 6 months, and borrowers would ultimately not be paying principal, interest, or fees on the loan because that 6-month period would coincide with the loan forgiveness program and application period as well. The PPFA amended that provision a bit to require that lenders defer payments until the date on which the amount of loan forgiveness is either remitted to the lender, including for PPP loans that are ultimately sold on the secondary market. And the reason that this is the case is because the PPFA also extends out the loan forgiveness period. So again, they're trying in this new law to track the deferment period, to capture, to have the deferment period track the forgiveness period, and to try to capture the initial instinct and purpose of the law, which was to allow for a full grant, for the loan to be converted into a full grant, and to not require that any payment on principal, interest, and fees be made if in fact a borrower's loan can be converted into a grant. So these deferral provisions are very important. They certainly inform decisions that borrowers are going to be making about when they seek forgiveness and how they go about seeking forgiveness in light of the PPFA's new provisions. My partner Meredith is going to address these covered periods and what this means as a practical matter going forward for those on the phone seeking to look to how they can get their loan forgiven in light of the new provisions that came out of the PPFA. And so Meredith, if you want to walk us through the covered period changes.
Sure, thank you. Yes, the original CARES Act PPP involves 2 covered periods, and that has always been a bit of a source of confusion. The Flexibility Act continues perpetrates the confusion and develops it in new and different ways. So the first covered period is the broader kind of overall covered period for the program. Originally under the CARES Act, the PPP covered period was going to end on June 30th, 2020. The Flexibility Act, the PPPFA, extends that out to the end of the year, to December 31, 2020. This caused some confusion because the question was, well, can people continue to apply for loans after June 30th, 2020, all the way through the end of the year? And immediately after the passage of the PPPFA, certain members of Congress wrote a letter stating that the intention of the new law was to allow businesses to have extra time to spend the funds, but not to allow businesses to keep applying for loans after that June 30th date. So the amended IFR, which came out a few days later, did confirm the statement that was in that letter from members of Congress and makes clear that the last day that a lender can obtain an SBA loan number for a PPP loan is June 30th, 2020. So despite the change in the statute's covered period, the expectation is that loans will not be issued, indefinitely or to the end of the year. That June 30th is still a sticking point. There is also a second covered period, and that relates to forgiveness. And I know that this is the period that's probably on the minds of most of the participants in this webinar. This is the period that initially was the 8-week period. And the CARES Act stated that the loan had to be spent and forgiveness was available 8 weeks following loan origination. A subsequent IFR clarified that it was 8 weeks after disbursement. And now the PPPFA, again, tracking sort of the prior confusion, states that it's the earlier of 24 weeks after origination of the loan or December 31, 2020. Now, the IFR itself clarified that and once again confirmed that it is the disbursement date that controls. However, there's a couple of nuances here. One is that for borrowers who already have a pre-existing PPP loan, they may elect to keep that 8-week covered period. The second is that it's not automatically that you get a covered period that goes to the end of the year. You have to look at your loan, and I believe for most people, most businesses that obtain their loans in, the last several weeks and months, it's going to be that 24-week period that applies. It's not the December 31, 2020 period that's going to apply for your forgiveness covered period. What the statute and the rule do not explain, and we've received many, many questions on this, is what happens if you need more than 8 weeks, but less than 24 weeks. If you exhaust your funds at week 11, can you apply for forgiveness at week 12? The answer is not, there is no answer in the current guidance. We think that that's the reasonable approach. And we are very hopeful that the forthcoming revised application, and there will have to be, we assume, a revised application to implement some of these different changes that the PPPFA has brought upon us. But right now, that is still an open question. Another question that relates directly to that is, what happens if I spend my money at week 11, I apply for forgiveness at week 12, am I on the hook for layoffs that may occur in week 16 if I have to lay people off due to economic circumstances, just haven't been able to help me get my business back in line? Again, that's unclear whether headcount reductions after you exhaust the funds are still going to be potentially impactful for your forgiveness amount, but we are following that very closely, and we hope to have some clarity on that soon. I'm going to turn the discussion over to our colleague, Art Cyrilnik. He's going to explain another significant change that the PPPFA brings, and that's with respect to how the funds must be used.
Thanks very much, Meredith. Just let me start by anybody who wants CLE credits. The password for today's program is flexibility. I'm going to discuss a shift from the 75-25% requirement in some of the prior rules to now what is 60-40 in the new rules. And so let's start, where did we begin? When this whole process began, there was no guidance at all in the original legislation on how your money needed to be spent for forgiveness. All money that was spent on eligible expenses, be it payroll or certain specific non-payroll expenses, including rent, utilities, and interest on certain obligations, was eligible for forgiveness. But in the IFR that was issued on April 3rd, the rule is implemented saying that no more than at least no more than 25% in effect of the money could be spent on non-payroll expenses if there was going to be forgiveness. And there was a lot of question as to whether if you only spent, for example, 74% of your borrowed funds on payroll, whether you were entitled to any forgiveness at all, or in other words, that 75% was a minimum threshold, or whether it was just a reduction in your permissible forgiveness. After a lot of back and forth, it seems that a consensus was reached that you could still get forgiveness even if you didn't spend 75%, but there would be a cap on your non-payroll expenses as far as forgiveness goes. Then the PPPFA came along and said that you must spend 60% of the PPP funds on payroll items in order to be entitled to forgiveness. So it seemed to go back to a minimum threshold as opposed to just a reduction in the amount that was available for forgiveness. But then what happened is the IFR came out and specifically said that, in fact, the 60% is not a minimum threshold, that it is just a limitation on how much non-payroll expenses can be used, can be counted towards the forgiveness. So they give an example, which you're going to see on the slide. It says, if in fact you've received a $100,000 PPP loan and during the covered period, the borrower only spends $54,000 or 54% on its loan on payroll costs, then because the borrower used less than 60% of its loan on payroll costs, the maximum amount of loan forgiveness the borrower may receive is $90,000, with $54,000 of it being payroll and $36,000 on non-payroll. And so that is now the rule. So there's a tremendous amount more flexibility, for the ability to spend loan proceeds on non-payroll costs. The other thing is, it's just, I think, going to be easier to meet altogether, just to harken back to the fact that we now have a 24-week period, unless you opt into the 8-week period. It's going to be a lot easier for people to spend their funds on permissible uses. Probably meeting even the 75% threshold isn't going to be a problem, because instead of having 8 weeks to spend it on that, you're now going to have 24. But in any event, the new threshold is 60%. So if you want to have the maximum loan forgiveness, you have to spend at least 60% on payroll-related expenses and not more than 40% on non-payroll-related expenses. Though not on my slide, I was asked to address a couple of issues that came up after our last webinar. And one of them was to explain, we'd had a discussion previously about how do you compare the accrual basis versus the cash basis for determining both payroll and non-payroll costs. So what I wanted to do is start with the non-payroll costs, because it's a little bit easier to explain there. What happens is, under the rules, you get forgiveness for any amounts either paid or incurred during the covered period. Now, once again, with a 24-week period, if people opt for that, this shouldn't be a big issue. People aren't going to necessarily need to cram expenses into the 24-week period. It should just sort itself out because of the longer period. But notwithstanding that, the issue still exists, and especially it exists for those who opt to have the 8-week period, even more so. And so they give in the IFR, they give an explanation as to how this works for non-payroll expenses. And the example they give is as follows. A borrower has a covered period that begins June 1st and ends on July 26th. The borrower pays its May and June electricity bills during that period, between June 1 and July 26th, and pays its July electricity bill on August 10th, which is the next regular billing date, but which is outside the covered period. The covered period ended on July 26th. What they say is here, the borrower may seek loan forgiveness for its May and June electricity bills because they were paid during the covered period. Remember, it's either paid or incurred, so those were paid. It says, in addition, the borrower may seek loan forgiveness for the portion of its July electricity bill through July 26th, which was the last date of the covered period, because it was incurred during the covered period and paid on the next regular billing date, which is the rule that if you use the accrual method, you have to pay it by the next regular billing date. So what happens here is, when they paid their May bill, they got their full May bill covered that they paid in June. They got their full June bill covered when they paid it in July. And now they're getting 26 days of July that they're being billed in August. So it's just short of 3 full months, even though the contemplation was it was supposed to be spent during the 8-week period. So that's how that works. So now a similar issue relates to payroll. We just discussed non-payroll. And payroll technically has the same kind of issues. In your first payroll period, let's just say it's June 1st, you could be paying your May the 15th to May 31st payroll, and that would be paid. And if you carry this forward, just like with the non-payroll expenses, where you may have a bill that's due after the 8-week period, that's paid, a bill that's paid outside the 8-week period towards the 8-week period, arguably, just like with the non-payroll expenses, where you're getting, in my example, about 11 or more weeks covered, the payroll rules seem to be written the same way. And I was asked this question actually right after the last webinar. And I think the answer still is that for those people who have an 8-week period, it's going to be 8 weeks of payroll. And for those who have a 24-week period, it's going to be 24. The language that the example given for the non-payroll expenses, which specifically demonstrates more than 8 weeks of payments being made, they don't give the same example for the payroll expenses. The language is poorly drafted and could lead to that conclusion, but I think our view is still that if it's 8 weeks of an 8-week period, you're going to get 8 weeks of payroll. If it's 24-week period, you're going to have 24 weeks of payroll. And so I think that's our view on that. I was also asked to answer one other question, which is how are utility costs covered as far as a permissible expense? And the language allows for payments that are made for this. You covered utility payments, include business payments for service for the distribution of electricity, gas, water, transportation, telephone, or internet access, for which service began prior to February 15th, 2020. Most of those things are really kind of self-explanatory. You know what your electric, gas, water, telephone, and internet access costs are. But one of the questions is what is a transportation cost, and there's no guidance given on that at all. And so at least one opinion seems to be that you would do it the same way that you're kind of calculating this for your tax filings. One would be that you would take your standard, assuming it's applying to use of cars, you take your standard mileage rate, where you don't, all you have to do is track your miles driven, and you would multiply that by 57.5 cents per mile, which is the rate that applies to 2020, and those would be your transportation costs. Another way to look at it is to actually track every single expense and use your actual expenses rather than the per mile expense. And that would include costs such as gas, oil, and repairs. And so that's how we see covered utility, permissible, expenses for utilities. And that's it for me, guys.
And Chris, if you can walk us through some other components of forgiveness as well, that would be really helpful, including around headcount and other aspects of this program.
Sure. So it's Chris O'Brien from the Los Angeles office. A couple of points about headcount calculations that came out in the Flexibility Act. And these aren't really addressed in the amended IFRs. They're really just in the Act. So there isn't a tremendous amount of guidance, and hopefully we're going to get some more guidance because things aren't crystal clear. But chances are, if you're listening to this webcast on a Friday afternoon, you're pretty deep into the PPP, and you know already that the CARES Act reduced borrowers' eligibility for loan forgiveness if there were reductions in full-time equivalent employees or reductions in compensation for employees below $100,000 in annual comp between February 15th and April 26th. But there was an ability, or there is an ability for an employer to avoid forgiveness reduction by restoring those FTEs or that compensation cut by June 30th, 2020. That June 30th, 2020 date has been pushed out now to December 31, 2020. The reason I say there's unclarity here is, as my colleague Meredith pointed out, I think Art alluded to as well, it's not clear whether a borrower gets to pick a point between 8 weeks and 24 weeks. It's clear that you can use the original 8 weeks as your forgiveness period. It's clear that there's a new 24-week period. It's not clear what happens between those dates. We just don't have guidance as to whether a borrower gets to choose one of those interim periods as their forgiveness period. It's also not clear, and we've had this question, whether an employer could wait until essentially 12/31 or the end of their 24-week period and make offers or increase the compensation rate at the very end, even if they've expended the funds before that, and still get credit under this provision for rehiring employees or restoring compensation. It just isn't clear, and it's also never been clear that whether an employer could restore compensation or FTEs and then immediately after or soon after the period drop the compensation or drop the employees, and in that sense still get out of the forgiveness reduction, even though there's a very short period of time when they increase the headcount or the compensation. Those questions just aren't answered, and we're hoping for more guidance. One footnote question that I was asked to address is FTE counting when there are part-time employees, and the answer is in the regulations, and basically you get to pick one of two methodologies. And if you've got part-time employees, you can add those up to be a single FTE or full-time equivalent. You either, and you don't do it on an employee-by-employee basis, you pick a methodology. You either use a fractional share. So let's say you had an employee who was a 30-hour-a-week employee. They would be 0.75 of an FTE, 40 hours being a full-time employee. If you had somebody who was a 10-hour-a-week employee, they would be 0.25 or a quarter of a full-time equivalent. That's one way to do the counting. The other way would be simply to ascribe all the part-timers as a 0.50 or half of an FTE. And there are businesses, I suppose, where they have a large number of employees who don't come up to half of a full-time employee, and that may be an advantageous way to do the counting. Good news is everybody gets to pick, and you should be able to do the calculation both ways and figure out which one's more advantageous. We can go over to the next slide. So the Flexibility Act also adds a couple of more interesting facets to the forgiveness reductions. So if an employer is in a situation where they might not otherwise get forgiveness, but they can document an inability to rehire individuals who were employed on February 15th and an inability to hire similarly qualified employees on or before December 31, 2020, they can avoid the forgiveness reductions. I think the scenario this is aimed at is maybe a business that has specialized or employees with specialized skills and simply finds that they can't hire them after layoffs, or if the economy is in better shape and it's just generally more difficult to rehire employees or similarly qualified employees, and you can document that inability. There's an ability here to reduce or avoid the reduction in forgiveness amounts. The other, which is the third bullet point here on the slide, the other interesting addition here is if a business can document its inability to, quote, return to the same level of business activity that was happening before February 15th, and the language matters here, so I'll quote it, due to compliance with the requirements established or guidance issued by certain federal agencies, and the agencies are called out. It's the CDC, Health and Human Services, or OSHA, and those regulations are related to standards for sanitation, social distancing, or other worker or customer safety requirements related to COVID-19, then that employer could also avoid the forgiveness reductions. We don't know exactly what the regulations mean or the law means when it uses the phrase return to the same level of business activity. It's relatively clear that it's compliance with federal regulations and not state or local. State or local regulations are not called out here as a basis for avoiding the reduction in forgiveness. We've had a question about how to document the inability to return to the same level of business activity. There isn't any guidance in the statute, but I think a common sense approach is to document the regulations that are referenced that could affect the individual business, and then business records that show, for example, a decrease in revenue or a decrease in business activity, or customers who canceled orders, or whatever's relevant to the particular business to show the decrease in business activity. These are a couple of major examples, I think, of how the PPP Act is becoming more flexible and more protective of borrowers as business owners, maybe less of a paycheck protection and more of a protection of businesses as we get deeper into the shutdown and deeper into what may be a deep recessionary economy. And I think we expect those trends to continue, and we may see more flexibility when we read the application or see additional guidance from Treasury and the SBA. With that, I'll turn it over to, I think, Chuck to talk about deferral and payment provisions.
Thank you very much, Chris, and good afternoon, all. This is Chuck Morton, and it's my pleasure to be here this afternoon. We're actually doing pretty well on time, so I'll take a minute to try to address a few of the questions that have been posed. And the first has to do with payroll. There's an observation that someone's still a little confused. Let me take a stab at it, invite Art to correct me if I'm wrong. But as with the non-payroll expenses, you get the benefit of the cash basis at the front end of your applicable period, such that if you pay a payroll at day 5 of either your 8 or 24-week period, you get the full benefit of all the sums that are paid on that date. And at the back end, you get the benefit of accrual, meaning that if there's payroll that has been accrued but not paid at the back end, that in essence, you get to extend the time horizon. Now, I will say that that was inconsistent with how we had originally interpreted the PPP, but it seems to be the direction that the guidance is taking us. Art, is that a fair description?
Yeah, I think the answer is yes, Chuck. Literally, the language says that. I think our concern is that when they kind of applied the same concept to non-payroll, they said, we're okay giving you more than 8 weeks because, at least at the time, non-payroll was capped at 25%. And so there were natural limits built in. There's no such language addressing payroll. And I said, I have gotten this question. We've discussed it internally in the group. And I think our view was, yes, we all agree the language seems to say that you can kind of use, paid up front and accrual on the back end, but it just doesn't feel right to any of us. So we're not sure, because it would then be extending the payroll beyond the 8 or 24-week period. So the literal language seems to lead to that conclusion. Our guts are leading us to question that, Chuck, I guess is my view.
Yeah, and our practical resolution to this, given the ability to extend out 24 weeks, is that we do not expect there will be many scenarios under which, at least applying the 24-week time horizon, it should be hard to hit the numbers. Now, as we continue to see more and more actual cases, perhaps we'll revisit that. But at least so far, that's our collective sense. Second question is, are car leases, equipment leases, et cetera, the subject that or expenses that are subject to forgiveness? And the answer is yes, that those are leases that we think are covered. And then the third that I'll address is by an attendee whose business owns a business office as a condo, at which they pay certain maintenance fees as part of the condo expense. And their question is, do the maintenance fees count as rent for PPP? And I'd be curious, Art, to hear your thoughts about that. My gut would say probably, but again, my sense is if you're taking advantage of the full 24-week time horizon, that some of these classifications become much more academic than real. what's your thought about maintenance fees, Art?
Yeah, I don't really know, Chuck, to tell you the truth.
Yeah.
I think our view has been on any of these things where it's questionable and we're not really sure that it's covered, just kind of flag it in your forgiveness application so you don't appear to be misleading anyone. I don't know if we're going to get any more guidance. That's the first time I've actually heard that question over the months that we've been dealing with this. But it's, you know, is it a lease? It's a lease. It's a lease of the condo. Is that, or the condo's owned? Is it?
The condo's owned. So in the fact pattern, as we understand in this, it's like questions by Twitter almost, given the way these come up. But it appears to be owned by the borrower, but it has regular maintenance fees, as condos typically have, which certainly can be some scenario into which you think about it as rent. Again, one of the things that's happened, at least for the clients with whom I'm working every day, since the Flexibility Act, is some of these questions have become far less important once you have the full benefit of a longer period of time. So that the ability to get to things that are clearly forgivable have become much, much easier. And some of the efforts to try to race to spend the money have come to an end as people step back and try to absorb the longer time horizon. But
hey, Chuck.
But sure.
If I could jump in, since we do seem to have a little bit of time, and I want to kind of ask what seems to be what would be a logical question of Meredith, which is, you know, as we're talking about everything becomes easier if we have a 24-week period, why would anybody pick an 8-week period? And I know we've discussed that internally, but Meredith, maybe you could share the thoughts with everybody as to why people might still want an 8-week period, even though the 24-week period is available and would make it easier, basically, to spend your money in a forgivable way.
Sure. So I think one straightforward reason is, you know, you were fortunate enough to have received a loan amount that you were able to spend in the 8 weeks, and you want your forgiveness process to get kickstarted. You don't want to wait, you know, potentially 24 weeks to start that. And so, you know, I do think there are some businesses that are in a position to seek forgiveness and seek maximum forgiveness or close to maximum forgiveness at the 8-week juncture. So that's, you know, for those businesses, that's probably a logical step, is to just go ahead as those, you know, business as usual, go for the 8 weeks and not push this out unnecessarily. For other businesses, I think it's more complicated. They may not have reached full forgiveness, but there may be other countervailing business needs that weigh in favor of perhaps, you know, applying for their forgiveness as is and understanding that they may not get 100% forgiveness, but they may have other business needs that drive their desire to potentially, you know, I don't want to say escape, but get out from under the SBA program so they can move on with their business planning in these difficult times. And I know that there are, you know, are certainly businesses that, even though the PPP program was a big help in keeping their employees on the payroll for this 8-week period, there are some hard decisions that may need to be made over the next coming weeks as to whether they can continue to keep employees on the payroll for the longer term. And so that business reality may cause some borrowers to decide that they would like to, you know, take the 8 weeks, which is what they planned for, apply for forgiveness, and then, you know, kind of move on with their lives and figure out what the next step is for their business planning. I don't know if you all have a different sense of that, but I think that that's an unfortunate reality that many businesses are still confronting as the weeks tick on.
Right. So Meredith, just to amplify what you're saying is, if you have an 8-week period now and you've made your rehire offers or things along those lines, or you brought your people back on, technically, if you now apply for your forgiveness in a month or two from now, you need to lay people off again. You can do so without any consequence to your FTE count and stuff like that. But if in fact you do stay for the 24-week period, anything you're doing kind of between now and the end of that 24-week period is arguably going to hurt you on the FTE count. You do have another curative period on December 31st, but then you may need to be making rehire offers to people that you don't otherwise really need to rehire. Is that fair characterization?
Yeah, I think that's right. And you know, this is tempered by we haven't received any real helpful guidance on how these rehire provisions are going to be treated in this longer 24-week world that the PPPFA has created. But I agree with you, Art. I think that that's a good overview of the decision-making that's going on.
One related point, and then we can take it back to the slides, is whether or not one could apply for forgiveness at week 12 or 13 and have some to take the position that your eligible period was somewhere between 8 and 24 weeks, and that there's just not guidance yet on that, and it's just not clear. At least my gut tells me that they don't want everyone applying for forgiveness at the same time, that the system would be overwhelmed, and that there's likely to be some accommodation for interim applications for forgiveness, but that is still not clear. However, one thing that at least was cleared up in the PPFA has to do with payroll tax deferral. Originally, under the CARES Act, businesses were able to defer employer payroll taxes, so just over 6% until the end of the year as a way to save cash. However, the CARES Act excluded borrowers who received loan forgiveness from being able to defer their payroll taxes or otherwise take advantage of that relief. The Flexibility Act changed that and made it clear that even if you did take advantage of forgiveness, that you could still defer employer payroll taxes, thus saving folks a great deal of money through the end of the year. Other things, though, that haven't changed, or at least not explicitly, are the review process and what it is that will happen or can happen as the SBA potentially reviews these loans. The PPFA makes clear that the SBA may review any PPP loans at any time at its discretion, and that the SBA may consider in that review whether a borrower correctly calculated the loan amount, properly used the loan proceeds, and or is entitled to the loan forgiveness amount sought. So there is a blanket opportunity to review that is tempered by guidance that suggests that loans of more than $2 million all will be audited, suggesting that amounts of under $2 million are less likely to be audited, and for practical purposes, we think are less likely to be reviewed. But the SBA has made it clear that that guidance does not provide a complete blank check for folks to do whatever they wish to do in an unfettered way. Borrowers are obligated to retain their PPP documentation for at least 6 years after the date the loan is forgiven or paid in full. So if you've prepared loan applications, be careful to save the applications and all of the supporting documentation related to those documents. The SBA Inspector General must be granted access to those files upon request, so just be certain that you keep those things. If the SBA believes a borrower may be ineligible for the loan or have some forgiveness for some forgiveness amount, it will require the lender to make a written request for additional information from the borrower, and it may also request information directly from the borrower. So there are ways that the SBA and the Inspector General can include the lender in the enforcement efforts. All information provided by the borrower in response either to the banks or the SBA is to be considered in the SBA's review. And if you fail to respond to the SBA's request for information, it may result in a determination that the borrower is ineligible for forgiveness or for the loan itself. Query what happens if you were ineligible for the loan, but certainly ineligible for forgiveness. One attractive aspect of the PPP was that it did not have any recourse provisions, no guarantees, personal guarantees related to the loans. If it is determined that a borrower has been ineligible to receive the PPP, the loan will not be protected by the non-recourse provisions, which is legal way to try to suggest that individuals could be responsible for the loans that they would not otherwise be responsible for. And finally, in the context of the review process, the borrowers will be given the opportunity to seek reconsideration and appeal of any review decisions, so there is some due process here. So this is all just designed to make it clear that there's a process in place for the SBA and banks to be certain that everything was done on the up and up. There's been a lot of attention on the audit process, particularly when the SBA made it clear that all loans north of $2 million would be audited. We have some practical suggestions for how to prepare for that. First, we want you to have a clean file with all your calculations and supporting material submitted as part of the initial applications. That should include any board resolutions or discussions around the need for the loan. It should include any calculations that underline the amount of the loan. And then relatedly, the file should include all of the backup material for whatever forgiveness application is filled out. Obviously, we expect that application to be updated, but as you're filling out the application, there's certain data that you're obligated to collect, and we just encourage you to keep all of that information segregated in a clean file and presume that those documents, that information and analysis will be sought as part of the audit process. Next, we recommend, and obviously most of you are probably already into the loan, but we've encouraged folks, unless your bank says otherwise, to segregate the loan proceeds to make it easier to track the expenditure of those loans. We encourage you to prepare a forgiveness model to track forgivable expenditures and to have that model reviewed and signed off on by counsel and accounting support. This is a little less pressure-filled now, assuming a 24-week time horizon. But if you're still working under the 8-week time horizon, you want to be certain that that you've thought through the nuances of this clearly, particularly given how much ambiguity there's been around some of this guidance. We encourage you to closely follow and document any direction from lenders. Our view is that some lenders are giving guidance that's inconsistent with the PPP overall. So if you're compelled to follow that lender guidance, we encourage you to document it, include it in your file, and just be certain that no one can doubt why it is that you've done certain things. As it relates to tracking expenditures, for example, leases or utility payments, various bills, anything that you're going to seek forgiveness for, we encourage you to keep those bills in this audit file, so that if someone's curious about your lease expenses, that you have a copy of the lease that should show the specific payments are made consistent with that lease. If you're doing this along the way, then the audit itself should not be such a tremendous burden. And if you've got a loan of more than $2 million, you know it's coming. So we strongly encourage you to be preparing the documentation as we go in real time to try to ease some of the pain. So Allison, that sort of brings us to what's next and what we think is coming. And I think our intention here is to go around the horn and get the collective sense of the group.
Yeah, thank you, Chuck. So we want to poll our panelists and get a sense from them of what they expect is coming next. So I will start with Meredith. If you can give us a sense of what you expect be coming down the pike here as we look at the PPFA and we see the additional rules that came out on Monday, and we hear talk about new money as well.
Sure. So I always feel like we're at an information deficit here. So I'm looking forward, to the extent one can look forward to receiving guidance to the next round of FAQs and the new application. I found that the forgiveness application that came out for the originally contemplated program was pretty helpful in framing some of the issues and the questions we had. And so maybe the Redux 24-week application will have some finer tuning as well. You know, these things tend to come out at inconvenient times, usually Friday nights around 10 o'clock. So we'll see if we get something this weekend. But, you know, I think that will go a long way to resolving some of the questions we've been discussing on this presentation.
How about you, Art? Art, what are you looking at in the future? What do you think comes next?
I'm sorry, I was on mute and talking to myself, so now I'll talk to everybody else. I think we, you know, as we alluded to during the discussion, there's a lot of complications now with the 8 to 24 week period. The interim forgiveness, can you shut it down after 11 or 12 weeks? Things like that. If in fact they say that you can kind of shut it down in 11 or 12 weeks, when is like the rehire provision going to kick into place? Because right now it seems if you want to solve FTE shortfalls by hiring people back, your dates are June 30th or December 31st. What if you want to basically close out your loan and seek forgiveness in September? What does that really mean? So I think there are a tremendous number of unanswered questions with that new change in the rules, where I think we're going to have to see guidance, because right now we're just left with a lot of unanswered questions.
And Chris, what are you forecasting for the PPPFA and the PPP loan programs?
Well, I'm going to go out on a limb and say more of the same. I think, you know, from a big picture perspective, if I can try to read the tea leaves of what 400 plus people in Congress had in mind here, I think there was an idea in the beginning that we'd have an 8-week shutdown of the economy, and that this act would help keep people employed and keep lights on in businesses. And then we'd all come back after 8 weeks after defeating the coronavirus and pick up where we left off, and this act would sort of plug a gap in revenues and payrolls. And obviously that's not what's going to happen, and it's not what's happening. The shutdown is lasting longer, and the economic effects are going to be deeper and longer than 8 weeks. So I think what's happening is that the administration of the program is taking that into account and lengthening the time for forgiveness, lengthening the covered periods, making forgiveness easier, because the reality is we're not just plugging an 8-week gap. We're addressing real existential crises for a lot of small businesses. I think 100,000 small businesses are permanently closed during the shutdown here. But I think we're going to see the trend line of more forgiveness and the regulators giving more forgiveness than Congress even contemplated continuing as the economic effects of this display themselves as being worse and worse.
And you, Chuck, what are you forecasting?
Well, I'll pick up on the riff from Chris, and ironically, I think what we're seeing is that those who were slow to get approval are actually in a better position because they end up having more flexibility with how to use the money. And what I've seen since the passage of the PPFA is business owners trying to think more about what their business needs are with the money that they've gotten through the PPP than simply how to ensure that they're able to check all the boxes to get forgiveness to happen, which I think ultimately is a very good thing for the reasons Chris identified in terms of the depth and length of the economic challenges that we face. So I'm watching some clients struggle with the actually near-term layoffs rather than bringing people back who still aren't able to be fully engaged in the hopes of preserving money for later in the year when hopefully it will be more helpful for the sustainability of the business, and using the recent changes to help facilitate that. So those are some of the most difficult conversations I'm having with clients now. And those conversations are more impactful for clients who were slow to get the loans because they have more of their PPP money left than it is for those who were all over this at the front end, got the loan, and now maybe in some cases 8 weeks into it already, having spent the money consistent with how they were incentivized to spend the money. So the big picture, what I see is the programs continue to evolve in ways that reflect our evolving understanding of the crisis and providing more flexibility for business owners and people trying to make very difficult decisions about how to preserve cash in difficult business environments.
Thank you. That's all very helpful, and I'll tell you what I forecast. I'm looking at three things. I'm looking at additional money coming into a program either like the PPP or similar to the PPP. There's some initiatives in Congress now that we're paying attention to, including initiatives that would provide additional loans to companies with fewer than 100 employees. So I'm looking closely at that. I'm following closely and waiting on the rules and guidance from the SBA around how that agency is intending to conduct audits of files of borrowers who receive loans in excess of $2 million particularly. And number three, I'm following an interesting strain of thinking that has been in the air this week with some of my clients, which is concern about the way that the rules themselves have been applied and or written. And you may see, after all, some court challenges that come out of this because to the extent a borrower took money at the beginning of the program with a certain understanding and then subsequently learns that rules are being applied differently than expected, you may see that borrower be willing to challenge some of the conduct of the SBA. And so we're hearing and kind of seeing some of that in the air. And by that, I mean, I'm reading about that and, you know, candidly, occasionally having conversations with folks about that too. So those are three trends that I see. I want to thank everybody again for joining us today for our continued coverage of the PPP. It continues to be something that animates a lot of discussion and conversation and concern as well. Again, this is the new Paycheck Protection Program Flexibility Act. This webinar as part of Venable's ongoing monitoring of the PPP. Please stay tuned. We will probably be having another webinar, and we continue to publish alerts and monitor additions to the rules and to any additional laws that come out. I want to thank you for joining me. I'm Allison Baker, Chair of Venable's Financial Services Practice. I'm joined by my partners, Chuck Morton, Chair of Venable's Corporate Practice, Meredith Boylan, a partner in our Litigation and Financial Services Practice, Art Cyrilnik, a partner in our Corporate Practice, and Chris O'Brien, a partner in our Corporate Practice. Thank you again for your afternoon. We appreciate it.